I have a couple of things to say, if people will listen.
I noticed it's unclosed, right?
One, the first is to,
Yeah.
particularly for those who were not here last night, to welcome you to the Conference on Religious Accommodation in the Age of Civil Rights. One of the things that came out in the discussion last evening is something a theme that we'll be pursuing over the next day and a half, which is that the phrase in an age of civil rights is an important observation because the idea of accommodation both emerges in a particular historical context and takes on its meanings, different meanings, as the historical context changes. And we'll be seeing some of that today. That's the welcome and intellectual part that I have to say. The logistical part is our food is over here and will be over here all day. Their food is over there. Don't eat their food. Brad Sears, who's been done all the tremendous organizing logistical stuff here, said there's a brewing turf war. And it occurred to me to say, well, as in fried green tomatoes, we may be older and have more insurance, but they are younger and more vigorous. So in this turf war, I'm not sure that we would come out well. So, so there we go. Okay, so I'm now going to turn it over to Brad.
Good morning, everyone. I'm actually Brad Sears. Ben Sears is doing all the logistics, so he can help you with that. I would be a mess doing any of that. But welcome to today's discussions. We're actually going to start out with a great panel on the current clash. And I'm going to be relatively brief because I've asked the speakers to be brief to preserve time for your discussion. And we've also made a decision that we feel all of you have a lot of knowledge about what's going on with the current clash. So we're going to be less descriptive and more setting up a set of perspectives and frameworks that hopefully people can refer to throughout the day. We're also going to try to create a little bit of clash on our own. So I've asked each of the speakers to initially speak for 12 minutes, and then they'll each have a couple of minutes to identify points of disagreement or divergence with the other speakers. I come from the Williams Institute, and I think Nan Hunter sat down with our founder, Chuck Williams, probably 6 years ago and said, these are going to be the issues that really the Institute needs to engage in its work on LGBT rights. And I'm really proud that we're co-sponsoring this event. We've co-sponsored a couple of discussions in DC, at Princeton, trying to grapple with these issues. And when we put out model language, whether it's for an Employment Non-Discrimination Act, an executive order, or a model marriage law, we have to grapple with these issues on a very practical level. So I'm excited to be able to be here and participate in the discussion. I'm going to introduce each of the speakers before they speak, and we'll start with our first speaker, Fred Geddix, who's the Guy Anderson Chair and Professor of Law at BYU School of Law. He's widely published on law, religion, including being the author of 2 books, The Rhetoric of Church and State, A Critical Analysis of Religion Clause Jurisprudence, and Choosing the Dream, The Future of Religion in American Life. So, Fred.
Okay, I did a PowerPoint, always an adventure for me, and even more of an adventure is trying to pull it off. So since there are no tech people in the room, I hope it works out okay. I have chosen rhetorical disconnects, which is, this is pretty generic. Someone else has probably used this too, but I just made it up. These are arguments that Hobby Lobby rejects when the government makes them, but they seem to work pretty well when Hobby Lobby makes them on behalf of itself. But before I do that, I've been given the enviable task of summarizing the Hobby Lobby litigation in 2 minutes. So here we go. As most of you know, I think the actual statute, the Affordable Care Act, has a preventive healthcare services mandate These services are to be provided without cost sharing, without deductibles, co-payments, co-insurance, anything out of pocket beyond the basic monthly health care insurance premium. And the definition of preventive health care services was not contained in the statute and was delegated by HHS to the Health Services and Resources Health Resources and Services Administration. HRSA adopted a formulation that was put together by the Institutes of Medicine, which is an arm of the National Academy of Sciences, and that definition, as it turns out, included all FDA-approved contraception, and then HHS adopted the implementing regulations, which included all the things that we're arguing about lately. So these are the basic regulations. As I mentioned, all health insurance plans have to cover FDA-approved contraceptives without cost sharing. There's an exemption for churches, associations of churches, houses of worship, the nonprofit activities of religious orders. There's an accommodation of tax-exempt religious nonprofits. And since I only have 2 minutes, I'm not going to explain that because it would take a half an hour. But I think since you're laughing, you know at least what I'm talking about with the accommodation. There's an exemption of grandfathered plans, but there is no exemption or accommodation of for-profit businesses. And then we have the no plan tax. There's no place for footnotes here, but really we owe this to Marty Lederman, who has articulated this. If an employer offers a health plan, it must cover the mandated contraceptives, but an employer could decide to cancel its insurance. If the employer has less than 50 employees, then there isn't any tax. If the employer has 50 or more, then it must pay an annual tax of $2,000 per employee. And then, of course, employees who work for an employer that doesn't offer a health plan are eligible to purchase insurance on the exchanges with the government subsidies. Elements of a REFRA case. These are fairly straightforward. My personal view is that if the government's going to win, it's not going to win on rebutting what we might call either element of the prima facie case articulated by a claimant, but rather it's going to win on the compelling interest, no less restrictive alternative ground. And no Fred Geddick's presentation on the contraception mandate would be complete without an argument that third-party burdens violate the Establishment Clause. Supreme Court has never recognized a permissive accommodation of religion in the for-profit workplace that imposes significant costs on third parties who don't benefit from the accommodation. You can think of this in either of two ways. One is that it's simply an internal limit in the way that REFRA works. That is, it's a compelling government interest to avoid significant burdens on third parties. You can also think of the Establishment Clause as an external limit on REFRA in the same way that the Bill of Rights is an external limit on say, the Commerce Clause. So with that, here's the multiple precedents from multiple sources. So there's an Establishment Clause case that makes this point. United States versus Lee makes this point. TWA versus Hardison makes this point under Title VII. And then Cutter versus Wilkinson is about prisons, which some of which are for-profit. Some prisons are for-profit workplaces, but most of them are not. So we have a little CF there in front of Cutter. All right, so here's the first of my disconnects, rhetorical disconnects. Hobby Lobby argues during the oral argument about the unfairness of having to pay extra to practice its religion. This is an interchange in which several of the justices posed to Hobby Lobby's counsel, well, why don't you just cancel your policy and pay the tax, which is much less than it costs to run a health insurance plan, and everything is fine. Your employees can then go out on the exchanges and buy their insurance. They can get the contraceptives. You're not implicated in them. Everybody's happy. And there follows a 4 or 5 page exchange between the justices and Hobby Lobby's counsel, in which basically counsel is arguing that that would be more expensive for Hobby Lobby, that if it canceled its health policy and paid the tax, it would have to raise wages, and the increase in wages and the tax would result in Hobby Lobby's paying more than it's paying now. My personal favorite is the middle quotation. If we don't provide health insurance, it would have a huge burden on my client and their ability to track workers, and that, in fact, would cost them much more out of pocket. So it's okay, that is, it's not okay for Hobby Lobby to pay more out of pocket to practice its religion, but it's okay if the employees have to pay more out of pocket in order to enable Hobby Lobby to practice its religion. So that's disconnect number 1. Now, disconnect number 2 has to do with the compelling government interest. In Hobby Lobby's brief, it's described as the most demanding test known to constitutional law. That's the phrase and the attitude it employs whenever the government tries to argue that the contraception mandate is supported by a compelling governmental interest without a less restrictive alternative. But whenever one brings up alternative scenarios, all of a sudden this test morphs into what we are more familiar with, and that is a sort of loose balancing that the court has always done with respect to free exercise claims. And in fact, Hobby Lobby's counsel even quotes, well, he paraphrases with approval, Justice O'Connor's argument in Smith, in which he says, the courts can sort this out. The courts will make reasonable balances. You just have to trust them to separate, as he says, the sheep from the goats. And then there's a series of hypotheticals put to counsel: vaccinations, minimum wage, taxes. The government can satisfy compelling interest in all of these. Other statutes, the government can satisfy the compelling interest. It seems only to be when the government tries to satisfy the compelling interest test in the Hobby Lobby case itself that that becomes impossible. And then the next one is my personal favorite. The government can pay, but my political allies will walk barefoot over broken glass to keep this from happening. I've debated representatives from Beckett probably 5 or 6 times and other folks on the mandate, and they always mention Title X. The government already has a program, they say, that provides contraceptives for free. All we have to do is beef up Title X. So think about that. I mean, one of the reasons we're in this mess is that a single-payer system in the United States is dead on arrival, and I would suggest to you that even a single-payer system limited to contraception would be dead on arrival. That's why all of this is having to work through employer-provided health care plans. So you look through Hobby Lobby's amici, people and organizations who filed amicus briefs on Hobby Lobby's behalf. So we have Republican members of Congress. I think there were 2 Democratic members of Congress among the 100+ who signed amicus briefs who supported Hobby Lobby. We have Catholic bishops and theologians. We have evangelical Protestant leaders and theologians. We have the American Center for Law and Justice, the Rutherford Institute, the Eagles Forum. So if you're trying to build a coalition to, say, double Title X funding to supply contraceptives for free, I mean, can you think of a worse group of people to have to carry that flag? And so this one, I think, is particularly salient because the very people who are offering this as a less restrictive alternative are the same people who are trying to shut down Planned Parenthood funding and Planned Parenthood clinics and cut Title X funding. 2 minutes, right. Okay. I have 2 slides left, so we're on track. Let me just close then with what I think are 2 social facts. We live under a social welfare state, and obviously that entails constant friction between government and private life, including religious exercise. I also think that while most people have their beefs with the social welfare state, everybody has a set of social welfare entitlements they don't want to give up. And so, in my view, the social welfare state isn't going away anytime soon. And we also live in a radically plural society in which it is simply impossible in a practical sense to alleviate every religious burden caused by this friction between government and private life. And in my view, the only possible solution to that can be that we should accommodate religion, but only when we can do so without significant cost to others who don't believe or practice the religion being accommodated. Thank you. You want to turn this off, or?
Thanks. I'm going to ask the rest of the speakers to take the stage as I introduce the next speaker, who is Michael Huffland. He's Associate Professor and Associate Director of the Glaser Institute for Jewish Studies at Pepperdine School of Law, where he teaches on law and religion and multiculturalism in the law. He's authored a large number of law review articles on law and religion, including recently Litigating Religion, A Liberalism Sincerity, Religion's Role in the Public Square, and What is Church, Implied Consent, and the Conception Mandate. So Michael, you can take it from there.
Thanks so much.
I don't.
Is there a way to turn off the projector?
Close this up some. All right. 12 minutes, right? 12 minutes.
12 minutes.
12 minutes. Okay, I'm hitting my stopwatch. Here we go. Start. All right. Pleasure to be here today. Thanks so much to the conference organizers for getting things for putting this all together. I have the task this morning of discussing the current clash. When I tried to figure out what to speak about, 12 minutes didn't seem quite to be able to capture everything. So let me just start by saying that I take the current clash to be framed by 2 broad trends in a post-employment division v. Smith world. The first one, I think the one familiar to us, is the conflict between religious liberty and anti-discrimination norms, things like Hosanna Tabor, Hobby Lobby litigations, state RFRAs, recent controversy in Arizona, recent controversy in Kansas, all these things, many of which, almost all of which, fall under the rubric of RFRAs and how they'll work out over the long term. I take that to be kind of one of the most salient pieces of the current clash. The other piece of it that I think gets a little bit less airtime is some of the moves for what I would describe as facially neutral laws, but that ultimately target, at least in my view, minority religious communities. And here I have in mind the continued growth of anti-Sharia bills in the United States. And also I would include in this some of the attempted circumcision bans in various municipalities around the United States, which have a very different dynamic, at least in my mind, than some of the kind of Hosanna Tabor, Hobby Lobby controversies. So trying to filter all this and what to talk about, I'm going to try and spend my next 10 minutes and 28 seconds discussing whether and under what circumstances should religious institutions receive a special protection from otherwise valid laws. That's kind of the piece of this that I'm going to try to take out from all these current trends and to see how exactly to sort this all out. And I'm going to try and advance what I've referred to in some of my writing as an implied consent framework and how this would kind of apply to some of the things we've chatted about. Just one quick caveat, this framework, it's a little complicated when you're talking about the First Amendment side and the RFRA side. I'll try to touch a little bit here and there on some of the differences, but obviously there's a strong connection to the extent that RFRA tracks pre-Smith First Amendment doctrine. I'll try to say a little bit about that now, but a little bit more hopefully in the question and answers. So what do I mean by an implied consent framework? Here I have in mind the Supreme Court in 1872 in Watson v. Jones. What I take to be its view on white is we have this doctrine known as church, quote-unquote, church autonomy. The kind of salient sentence is, all who unite themselves to such a body, referring to a church, do so with an implied consent to this government and are bound to submit to it. My take on this is this idea was at its core voluntarist. It was this idea that individuals could join religious institutions, could do so via implied consent, and these religious institutions could become focal points where people would voluntarily join to pursue a shared conception of the good, certain shared values, shared principles, shared religious values, religious principles. And religious institutions allowed people to voluntarily join in this way so that they could lead sincere and authentic lives together as a group to pursue conceptions of faith and identity. That's kind of the short of it. There's obviously a lot more to say. But the idea here was that the religious institution, by authorizing it to make rules that dealt with the developing of religious doctrine, religious ideals, it helped people pursue their own individual conception of the good life, of the religious good life. It became this kind of institutional structure because of the way in which people pursue religion, very typically in collectivities. Okay. So I've said way too little about that, but I'd like to just say two consequences of this implied consent framework. First, at least to my mind, it means that the decisions of religious institutions, to the extent authorized by the implied consent of its members, the deference afforded those institutions shouldn't cover what the Supreme Court back in 1929 referred to as fraud, collusion, or arbitrariness. And the idea here is that if people impliedly consent to the authority of a religious institution, they give authority to pass good faith rulemaking, not decisions based on fraud or collusion. The standard in Gonzalez was pretty much discarded by the Supreme Court in the 1970s. I take this to be a mistake. If it's all about implied consent, then we have to ask what types of decisions are we granting implied consent to? And so if you want to get like a practical implication of this in a Hosanna Tabor type case, if we're asking about pretext, my view is, yeah, we can interrogate pretext. And I don't think it draws us into resolving impermissible religious questions. What's another implication of implied consent? Well, when you ask who is a religious institution, obviously something that comes up pretty heavily in the Hobby Lobby litigation, my view is there aren't such things as religious institutions, but there are institutions whose nature allow us to presume the implied consent of their members. And so the questions you want to ask is, to what extent is an institution so obviously and openly engaged in religious activity that when somebody signs up with that institution, there we have good reason to presume they're implicitly consenting to the authority of that institution to pass rules and doctrine that relate to religious activities. And if you want to get a sense of how this might shake out in the Hobby Lobby litigation, so Mardell, kind of the silent plaintiff, which is this 35 Christian bookstores that exclusively sell Christian books, my view here is they probably have a pretty strong claim to being a religious institution. Hobby Lobby, on the other hand, sells generic arts and crafts. At the same time, they take out hundreds of ads that ask people to know Jesus is Lord and Savior. And to me, that's when you put yourself out there in that way, it raises the question as to what extent do people know that you're really a religious institution. Therefore, when they sign up with you, maybe as employees, do they know that they're trying to participate in some sort of religious endeavor? By contrast, Conestoga Wood Specialties, I haven't really seen anything in the record that would lead me to conclude that they manifest their religious aspirations in a way that we would want to presume along the Watson v. Jones lines that they are, individuals are implicitly consenting to their authority. Okay, so that's kind of one piece of it, implied consent, and that tells us who might be a religious institution, who's a player in this game. Of course, being a player in this way, being a religious institution, doesn't end the inquiry. Then you have to kind of contend with the standard free exercise jurisprudence, and I'd like to say a little bit about that. So on the one hand, now that you're a religious institution, you still have to satisfy two more important criteria. One is you have to be sincere. My view is I think we do too little with the sincerity requirement. I think courts should do a lot more testing here. I think there are ways in which to consider the activities of religious institutions in light of their substantive religious doctrines. I'm committed to a view that I don't think there's really a problem for courts to engage in religious question inquiries. And so I think there's maybe a lot more we can do on the sincerity front to make sure that the institutions that are indeed religious institutions, that they're being sincere in the claims they make. By contrast, I have strong distaste for the idea that we can use the substantial burden inquiry, especially under RFRA, to really figure out the extent to which a particular imposition on religious doctrine is, to what extent it's religiously significant for a religious believer. That strikes me as a problem, as opposed to, of course, figuring out whether the financial side of things in fact imposes a religious burden. Here, to figure out how significant a particular doctrine is to somebody's religious worldview strikes me as something courts shouldn't engage in. On the flip side, the other side of this is not only do I think we can do more with sincerity, I think we can do more with the compelling government interest standard. Some of Fred's presentation just alluded to this. Sometimes we call it it's impossible to satisfy. I think kind of those rhetorical moves have put a lot of pressure on the system. By saying that we can't satisfy strict scrutiny, I think it's led people to try to find other ways in which to sort out the good claims from the bad claims, so to speak. We've tried to figure out maybe too much inquiry into the substantial burden side of things in a variety of ways. And I think we should be candid that the compelling government interest standard is a really useful standard. It allows courts to take account of civil society and its view on various values at various points in time. It allows courts to take the temperature of the United States and figure out what we think is okay and what's not okay. It's very Lockean in a certain way. We allow religious institutions and religious actors to do as much as they need to do until we say you can do no more here. The values at stake from the perspective of civil society are simply too high. Put concretely, maybe it's the type of doctrine that can allow us to differentiate between Bob Jones cases and circumcision bans. In one case, a RFRA shouldn't help, and in one case, maybe it very well should help. Compelling government interest standards shouldn't be set so high that it doesn't do the work it can as a safety valve to make sure that we're sorting the right cases in the right places. In sum, if I were to try to summarize some of my views here, religious accommodation should be evaluated on the front end and the back end. On the front end, we should be asking questions like sincerity, implied consent, and on the back end, we should be asking questions about fraud, collusion, and arbitrariness, and we should be thinking about compelling government interests. In the middle of all this, there should be a strong, at least in my view, a strong amount of deference to religious institutions. We shouldn't be imposing artificial distinctions, at least in my view, on for-profit and not-for-profit. That's not the question we should be asking. We should be asking to what extent do individuals understand the institution they're signing up with and are doing so with the goal of joining for some sort of collective pursuit of a religious good. That's the real question we should be asking. And I don't think we should be parsing religious doctrine in order to determine how religiously significant a particular burden is for a religious believer. Some of the government's language and some of its lower court briefing saying that by definition for-profit institutions are not religious strikes me as the type of language that does strong dignitary harm to religious institutions. To tell a religious institution that you think you're religious, but in our view you're really not, as opposed to saying you're religious, but maybe we have a compelling government interest that says we simply can't accommodate here. These types of dignitary harms are obviously strongly at stake in all of this litigation, and the extent to which we can formulate the doctrine to take into account all types of dignitary harms, I think would be incredibly useful. Thanks.
As we move from BYU and Pepperdine to Georgetown, we should pause and thank religiously affiliated institutions for the scholars that are here today. And our next speaker is
Since all of us are, yeah.
is Nan Hunter, who's Associate Dean of Graduate Programs at Georgetown University Law Center, as well as Professor of Law. She also has the great honor of being the Legal Scholarship Director at the Williams Institute. And among many things, she's author of the forthcoming book, Civil Rights 3.0 in a Nation of Widening Opportunities, ? The Civil Rights Act at 50. So Nan.
Thank you. I must say I'm an author of a chapter in that book, although that chapter might become a book. So you might turn out to be correct after all. So I'd like to start my effort at contributing to framing the clash here by actually going back to a phrase that Mark Tushnet used last night. And the phrase was the policy space occupied by religion. I thought that just captured very nicely and succinctly the reality with which we deal. And so I want to make 3 points sort of coming off that reality and suggest that these points might be helpful as we try and negotiate further what that policy space should look like. The first of my points is that simply it is a policy space, that this is not a space that's about the true meaning of anything. It's not about the true meaning of equality. It's not about the true meaning of the Word of God, because both of those concepts are constantly changing. Secondly, that in order to make the best and highest use of our attempts to negotiate in good faith and to enhance social peace, I'm going to suggest two threshold adjustments, one of which would impose a burden, so to speak, on what is thought of in terms of my views as being the other side, and one of which imposes a burden on what is thought of as being my side. The first is that compliance with a generally applicable law without more is not an endorsement of that law. That if we take the position that simple compliance communicates by itself a message of endorsement, then we undercut the whole edifice of civil rights laws and social welfare laws. The second point is that dissent from a particular civil rights law, which is to say, belief that there should not be equality for lesbians and gay men, or belief that same-sex marriage is wrong, is not immoral, and that my side should not use moralistic attacks in contesting those arguments. So first, this is a policy space. And this is what we are engaged in. We are engaged in what is obviously a rapidly changing, or certainly changing, doctrinal environment with regard to the meaning of religion, with regard to the meaning, for example, of the Establishment Clause. Think of the case of Rosenberger versus University of Virginia, in which the court not only held that the University of Virginia's decision the university's decision not to fund or subsidize a student newspaper because the content of the newspaper was about religion, that decision was not required by the Establishment Clause, and indeed that decision contravened the rights of the religious students involved with that newspaper. I agree with that decision, and I agreed with it then. And that is simply one example of the ways in which I think, especially on the Establishment Clause side, the doctrine of constitutional meanings of equality or other things has changed to fit the policy space that religion occupies. In terms of the sincerely held religious beliefs and how those are changing to fit the policy space that is being occupied, I think there are many examples. There were a number of examples that Martha Minow gave last night with regard to race, and especially the history of the Bob Jones case. There are certainly examples happening seemingly all the time with regard to same-sex marriage. And I would suggest to you that there are perhaps two, in terms of social meanings here, and we're not talking about legal meanings, there are two metrics to follow. One metric are the official positions of faith leaders, of leaders of various faith groups, and the other is the on-the-ground meaning of what ordinary people in those faith groups believe to be the message of their religion about a particular issue. And I would suggest to you that, and Andy Koppelman last night brought up the example of objectors to the public accommodations portion of the Civil Rights Act, suggesting that people who simply wanted to discriminate would race to claim a religious basis for that in this very opportunistic way. I would suggest to you that this situation is a little bit more complicated, that in fact many people at that time, if you had asked them, would have said in all sincerity, however wrongly, but in all sincerity, that it was their religion that taught them that their ministers taught them that, and that that's simply what they grew up believing. And that years later, because of generational change, you would not find that view prevalent today, but you would also find the view has changed because of change of individual opinions. That is, some of those people who in 1957 would have said what I just said would say today, you know, I was wrong. I've changed my mind. I've thought about it. I've changed my mind. And you could make rhetorical points by saying, but hey, you said you believed in the Bible as the inerrant source of truth. What happened? Did the Bible change? No. But I thought about it, and I changed. And I think that's perfectly okay. And I don't think it means that however wrong the belief was, that it was insincere or that it was not religious. Of course, I believe that a lot of racists with no religious foundation would have tried to take advantage of that. I'm sure there are people who object today to certain gay equality laws without really a religious basis. But I'm perfectly willing to accept that many of the objectors in the latter category have perfectly sincere religious beliefs. They grew up believing them. Their faith leaders have told them that, and that is the way that they read and interpret the scriptures. So what are we dealing with here? We're dealing with a policy space, and we're dealing with, I think, the duty to try and negotiate in good faith, because we're negotiating. We are trying to make deals, to put it in blunt terms. And indeed, we've already begun that. So that if you say to the folks, both in terms of the Affordable Care Act and in terms of gay marriage laws, if you say, well, why don't you negotiate? Well, the response is from, let's say, the civil rights advocates in the same-sex marriage context, we have negotiated. You know, read the New Hampshire statute, read the New York statute. There are exemptions in those statutes that have never existed before in terms of exemptions for persons, religious persons, not being forced to accord certain support to the performance or ceremonies of religion, of weddings. That didn't exist before. We have negotiated. If you say that to opponents of same-sex marriage, some of them will say, well, you know, we used to say that we were opponents of same-sex marriage, and now we are calling it a human liberty. And we are saying that we need more human liberty. We need human liberty on both sides. So we are changing. We are negotiating. So I don't accuse either side of failing to negotiate in good faith, because in fact, that's exactly what is going on. So what is my contribution to this? So I want to suggest that there are two threshold positions that impede us from achieving best case outcomes if indeed we are searching to maximize the best resolution that carries the most respect for people on both sides of these debates. And the first, I would suggest, is that if civil rights or social welfare laws are to be effective at all, minimally requires the principle that simple compliance with a generally applicable law does not communicate endorsement of that. There are many examples of that from civil rights cases. Examples that point out, for example, that if the restaurant next to you is serving all without regard to race, then if you do that because you're forced to, it doesn't send a message. You might sincerely object to it on whatever basis, but it doesn't send a message to the outside world. Now, I do not mean to suggest that there can never be an exemption from a generally applicable law, but I would place the burden of inquiry, if you will, to start at that location. And I think that is where we have placed the burden of inquiry to start in terms of civil rights laws that have to do with race issues. Because otherwise, I think, however sincere the objections, the effectiveness of these laws would collapse. How much time do I have, Brad?
2 minutes.
Great. So the last point, and this is directed to, as I said, my side, and that is I think we have to step back from a kind of moralistic civil rights discourse. It's very understandable that any kind of civil rights discourse in this country invokes morality because of our history. Our context for civil rights laws was truly an American sin of slavery and racism, and because the civil rights movement itself as a social movement was fueled by a sense of morality and, not incidentally, grounded in African American churches and supported strongly, especially I think by minority religions, specifically progressive Catholics and Jews. But I would argue that we need to let go of a little bit of that moralism for two reasons. One is that it leads to demonization of one's opponents. Gay people have been demonized for a long time, including by a number of people who did so in the voice of religious faith. So it's tempting to flip the demonization. But I would say we've got to rise above that. We have to let go of that. Demonization does not lead to any good place. And secondly, second reason for stepping back from what I am calling moralism is that moralism, I think, in the context of civil rights, reinforces the concept that discrimination is about finding the evil actor. It's about finding the individual bigot, eliminating animus, eliminating bigotry, eliminating haters. And, you know, I mean, it's a cliche to critique formal equality, right, for all of its shortcomings. But that argument is really consistent with an understanding of equality that stops at formal equality. That where we are today in understanding equality and civil rights, not so much with regard to lesbian and gay rights issues, because we haven't gotten formal equality yet on sexual orientation, but we appear to be on the cusp of it. But in principle, I think that the United States is at a point where the most serious challenge, and what we ought to dedicate ourselves, those of us on all sides of this who take civil rights principles most seriously, what we should dedicate ourselves to doing is fighting structural inequality, the embedded kind of inequality that does not necessarily flow from hateful views or bigoted views or ignorant views or however one wants to frame that. That we should take on a bigger sense of equality. And that is the kind of equality that I hope we will fight for, and I hope will animate the principles of the very real negotiation in which both sides are engaged. Thank you.
Thank you. Our last speaker is also from Georgetown, Marty Lederman, who's an associate professor of law there. He's also served as a deputy attorney general in the Department of Justice's Office of Legal Counsel. And he's author with David Barron of a two-part article in the Harvard Law Review, The Commander-in-Chief at the Lowest Ebb, A Constitutional History. He's going to have a few extra minutes because he's going to turn from not only presenting, kind of finishing, setting the table, but also turning to the clash and responding to some of the other speakers. And after him, each speaker will have a couple of minutes to respond to the other panelists.
Thanks very much, Brad. I'll try to build that in. I'm feeling a bit sheepish here because Fred, in about 6 PowerPoint slides, said what I said in about 140 single-space blog post pages about Hobby Lobby. I'm thinking I've picked the wrong social medium or something to do this. That was a great summary. So what I thought I would do, since we're sort of the lead-off panel today, is try to frame the questions maybe and to provoke a little bit about thinking about more specifically what the hard questions are for the panels that come after us in 2 or 3 ways that I think will tie together. The first will be, what is this really an acute problem now? What should we expect to see in terms of religious exemption claims as to civil rights laws broadly defined, anti-discrimination norms? Is this something that is more common now, will become more common with the spread of gay marriage? Does this really warrant 8 panels at the Harvard Law School, or is this going to be a tiny little minor problem? I actually think the answer to that question turns in part on what the court does in Hobby Lobby and on the way that we answer other questions, including the other one I want to focus on, which is we have talked last night and so far this morning just sort of broadly about the idea of religious claims to exemption or religious objections. And I want to suggest that that's not a singular thing, that there are all sorts of different religious claims, and that it's very difficult to articulate in a statute or in a judicial doctrine based on a RFRA or free exercise what sorts of religious claims ought to warrant exemptions. And that difficulty leads us to various different choices. And one of those choices, and the one that's being pushed in the Hobby Lobby case, I think leads us to an expansion that would make what I think is a fairly narrow conflict into something much more significant, or with the potential to be much more significant. So I'm just going to tick off what I think, but I'd love to hear what others think, are going to be the hot button issues, and whether I think they're really significant in numbers going forward. The ones we've heard the most about are like Elaine photography, right? Someone doesn't want to provide a service to a gay couple, doesn't want to participate in some way in their commitment ceremony, in their wedding, and the like, or wants to turn away a gay couple from a bed and breakfast, from a place of accommodation, from a restaurant. I tend to think the reason Elaine photography stands out is because it is so rare and unusual, and I'm skeptical that we're going to see that many claims of that sort going forward. We might see a handful as soon as the court extends gay marriage nationally in the next year or two. We might see more of those claims, but I don't know that there'll be that many, and 10 to 15 years from now, I doubt there will be any at all. It's not, as the Arizona example showed, it's really bad for business, among other things, to turn away customers in this way. So I think those will be the outliers. I don't mean to minimize the harms and the difficulties in those cases. They are acute, and if you're the person who's turned away, it's cold comfort to say there won't be very many of these cases. But I don't know that it's going to be a huge social problem. The second is funding conditions, and here, this is what I think will be the biggest issue, but other friends of mine in the audience have said they don't think so. So cases like Catholic Charities, right? Conditions on the receipt of government funds will increasingly require non-discrimination as to your employees, as to your customers, as to the people you're servicing, I think just as it has in the sex and race areas. And it strikes me that that's more likely to be a place of acute conflict, although I'd be interested to hear what others say. As someone was telling me last night, it's more unlikely that the denial of tax exemptions, as in Bob Jones, will be very acute, because legislatures will, for the foreseeable future, probably at the very least exempt religious institutions and churches from any rules that require non-discrimination in order to get certain tax status. But I would also be curious to hear what people say about that. So that leaves two other categories that I think don't get enough attention. One is sort of obvious, which is there will be a federal ENDA at some point. There will be norms, federal and local and state, prohibiting discrimination against employees on the basis of sexual orientation. And there may be more employers who are, for religious and other reasons, desiring to discriminate either in benefits, salary, or hiring against, and promotion and assignments against gay and lesbian people in employment than they are in provision of services to customers. So I think that might be and the final one is that I think, actually this sort of last night demonstrated this, I think there might be much more action in terms of discrimination against women than discrimination against gays and lesbians. I might be totally wrong about this, but I think Louise is right to have canvassed. Historically, there have always been claims by employers in particular that women should be treated differently, right? That they should be treated differently for religious reasons. That's not uncommon at all. I think virtually all of those cases have been rejected historically, but I'm afraid they might get some traction now, either on the basis of pregnancy or a proper women's role or proper jobs for women to have. That strikes me as also another possible fruitful area. So with all that in mind, how would you carve, if you wanted to do as I would like to do, and I agree with Dean Minow here, one would like to find a middle ground and carve out accommodations that will temper even these narrow areas of dispute. How would one describe what religious objections ought to be exempt? The devil's in that detail, and I think it's very difficult. Now, at the institutional level, when it's a legislature just trying to decide which institutions to exempt from certain things, it's a little bit easier, like the Obama administration did. It chose either a tax status to exempt certain religious organizations, or anyone who's a nonprofit religious organization affiliated with a church or something like that. That's a little bit easier to draw bright lines. The lines aren't perfect, but they're rough proxies for what you're trying to get at. But the claims that we're talking about are mostly claims that are conscience-based. They're individual claims of conscience, or individuals who work in or who run or who own companies. And when it comes to that, what does a religious exemption look like? Well, there's two ways to go. One way is to use RFRAs, right? To use state and federal RFRAs and just have a vague judicially enforceable standard such as, if this burdens your religion, you get into the test, or substantially burdens your religion, or perhaps if you have a religious objection. And then the courts have to deal with that. And I don't think that's been much of a problem in the commercial setting since 1944, and this is where Hobby Lobby really could make a difference. Because in every single case in the commercial setting under this test, call it strict scrutiny, call it whatever you want, for whatever reason, religious exemptions have never been given by courts or legislatures. Going back to Prince versus Massachusetts, there have been at least 9 or 10 Supreme Court cases, and Hobby Lobby threatens to be an inroads into that long history of whatever else might be the case. When you're in the commercial realm, and Hosanna Tabor is definitely an exception that we need to talk about, a free exercise compelled exception about who your speakers and ministers are in a religious organization. In the commercial setting, corporate or non-corporate, profit or non-profit, individual or organization, you don't get to have an exemption, largely for the reasons that Fred has described. Because in that setting, there's a very strong presumption that your religious exercise will come at the cost of other people's burdens, the burdens on others, significant burdens on others. It's only a strong presumption. It's not an irrebuttable presumption. Hobby Lobby threatens to undermine that not only with the result that the court might reach, but the reasoning on the substantial burden and compelling interest side that's being urged, which would radically alter what the court has done since the 1940s in this area, and I think would open up a whole lot more claims. So this came up at the oral argument last week. Paul Clement was trying to say, don't worry about the slippery slope. The courts, as Doug has articulated beautifully in his articles, the courts will deal with this. They're not going to grant the anti-discrimination or the Social Security or the wage and hour laws. They've never have. They've always lost. And Justice Kagan said, well, but if you guys win, if we rule for you, those cases are now wide open. The reason there haven't been very many of those cases is because the cases that have come to us, they've lost 9-0. Who would bring such a case? But after Hobby Lobby, I think it opens wide these questions again that had largely been settled in the commercial sphere for many decades. The other alternative, of course, is for the legislature to build in religious exemptions into the statute itself, and that's much harder than it seems when you're getting outside just defining certain institutions. What would that look like, right? Anyone who has a religious objection to the law doesn't get to, gets an exemption from it? That seems to be far too broad, right? Anyone who feels burdened in a religious way? I mean, think about it. It's not just that it will open it up to insincere claims. There is that risk, but I really want to push back on that theme that was being pressed last night. And this is Andy Koppelman's point. If you open this up, right now it seems like there won't be very many cases. But the opposition to gay and lesbian equality and to gays and lesbians and to their marriages is religiously, most people who have such objections are motivated by religion, sincerely motivated by religion. Maurice Bessinger of Piggy Park in the mid-60s was sincerely of the belief that if he let blacks and whites sit at his barbecue together, he would be complicit in a sin, that God commanded him not to allow the intermingling of races. I don't think that was insincere. Was he a racist? Of course he was. But he had a sincere religious belief. I don't think it's a matter of sincerity. I think it's a matter of, well, for one thing, if that's the case, why would you limit it to religious objections, right? Why not anyone who has moral or other objections to gay and lesbian equality, right? There's no reason in particular if just a moral objection or just a feeling of burden is enough, then you wouldn't limit it. And if we extended it beyond religion, of course no one would accept that, right? Of course that would never be acceptable. It would expand it very wide to anyone who wants to discriminate, because everyone is usually very sincere in having moral objections. Now, I just want to make one thing clear. I thought I saw Steve Smith somewhere in the audience here. Steve has just hi, Steve. A nice piece. I don't want to suggest, there's like this dichotomy that either this is some really, this religious objection to which we should give real solicitude, or it is, as Justice Kennedy infelicitously said, and I'll be nice, in Windsor, a bare desire to harm. I don't think that, I think Steve's right, that doesn't remotely describe the reasons that people want to discriminate. I think they are I don't have to tell all you guys what they are, right? Sometimes it's a desire to harm. Sometimes it's belief in, just a true belief in a religious view that they've been taught. Other times it might be discomfort or disgust or unfamiliarity with the unknown, with something, right? Social protest, a fear of dissolution of traditional sex roles, a conscious or unconscious impulse to preserve privileges and prerogatives and sex roles that have given those people advantages over the years. I don't need to tell you guys all the sources of discrimination against gays and lesbians. I don't think it's captured, I think Steve's exactly right, by bare desire to harm. That's part of it, but hardly everything. These things are common, and if you made a statutory exemption for religion, I think you would have to extend it to non-religion, and even if you didn't, most of these things could be articulated in religious terms because religion has a lot to do with why most people have these views about desire to discriminate. So then the question is, how do you describe, how much time do I have?
Like a minute to wrap up.
A minute, well, okay, so this is the provocation for the rest of the day to the extent you guys are interested. It's what I'm interested in. How do you describe it, right? Shouldn't certain sorts of religious claims be more worthy of our solicitude and legislatures and judges' solicitude than others? And I think so, yes, and here I agree very much. Doug thinks this has been going on, and I think he's right, sub rosa in the cases all along, right? That the cases set up a doctrine in which it's an all or nothing on-off switch. Is it a substantial burden? Yes, no. Is there a compelling interest? Yes, no. But of course what the courts have been doing is what they expressly did in Braunfeld, but not since, which is balance and take into account not centrality of religion, but how important that religious belief is to you and what the nature of your religious objection is. They are afraid to write that in the opinion because it's not the sort of thing that judges or any other civic officials should feel comfortable parsing, but it is going on, and I think it has to go on, and I think we have to come to terms with ways of assessing centrality, not centrality, but substantiality and depth of conviction, something that the military, by the way, does quite expressly in determining who should get the conscientious objector status, not only sincerity, but your depth of conviction, as demonstrated by at least two things. Are you able to articulate in a way that makes, not religious, but civic sense, why this sort of thing makes you complicit in something else that looks to be rather analogous does not? And secondly, have you engaged in what I call performative consistency? Have you been consistent about it? I'll tell you, I have 1,001 moral commitments and beliefs in how I should act morally. And some hundreds of them are religiously motivated or religiously inspired or religiously taught. And I'd say I comply with a small handful of those all the time. And others a lot of the time, but not always, because sometimes there's other good reasons for me not to, et cetera, et cetera. And the basic question is, if you are going, this is the point that Fred was making with respect to Hobby Lobby, if you are not walking the walk, it doesn't mean you're insincere. You're completely sincere, and it means a lot to you. But if you're not willing to pay a cost in the service of your religious commitments, including your claims of complicity and cooperation, it seems like a lot to ask other people who don't share your religion to bear those costs. Now, obviously, this is measuring incommensurables. I don't mean to minimize how difficult these inquiries were. In fact, I mean to basically tee up the fact that this is a really difficult and important question, and figuring out how we define the sort of religious burden that we're willing to grant an exemption to is much trickier and much more critical than than the discussion so far has admitted.
Great, thanks a lot. Yeah, and then why don't we just move back down the table, 1 to 2 minutes of kind of parting thoughts or places where you diverge from the other speakers.
I have three comments, one for each of my co-panelists. I strongly agree with Michael that the strict equal protection version of the compelling interest test puts enormous pressure on the rest of the system. And I just want to add, Chip Lupo has made this point, part of the reason for that is that the rest of REFRA, the rest of the structure is toothless. Once you give someone a blank check on substantial burden and say, all you have to do is raise your hand and say, I want an exemption, then something else has to act as a gatekeeper for exemptions, and that's been the compelling interest test, which I think is why it really can't mean what it seems to mean. That is, the scrutiny can't really be strict. I really enjoyed and appreciated Nan's remarks, and I guess I'll just offer this as someone who lives in an extremely conservative state, which is very, very religious and not particularly congenial to LGBT rights. I know that something that drives my conservative students crazy is the accusation that they are bigots. They're willing to concede, yeah, maybe the interests that the government offers in favor of same-sex marriage prohibitions are not sufficiently weighty to justify the prohibitions. But to take the next step and draw the inference that therefore the prohibitions are motivated by bigotry really angers them. And so if one is looking for some sort of political equilibrium or political compromise, I think one good idea is not to take the next step, not to draw that inference. Lastly, while Marty was talking, I was just thinking of an alternate political universe and maybe how path-dependent the entire contraception mandate controversy is. And so consider this hypothetical. Suppose the Obama administration, or HHS, when they articulated the regulations, had fully exempted churches from the beginning, had fully exempted religious nonprofits from the beginning, and then had done nothing for, as of course they didn't in the real world in which we live, for-profit corporations. I think part of the problem, part of the political problem here is that churches, religious organizations felt themselves at risk or under attack because the exemptions and the accommodations were not sufficiently permissive from the start. Had they been permissive from the start, I don't know how much sympathy Hobby Lobby would have generated if they had somehow jumped into the fray and said, me too. I'm a religious person, and I promise you what goes on in my church is not what goes on in a Hobby Lobby store. There's a difference. And I think there's a difference between Hosanna Tabor and the Amos case and Hobby Lobby as well. And I think that difference was obscured by the manner in which this controversy played out.
Thanks.
I get my 1 minute back, right? I had 1 minute, 15 seconds. Okay, good. Oh, awesome. Okay, so I just want to say a couple of things, I think primarily directed at some of Nan's and Marty's comments. And when I said in my opening comments that I'm in favor of kind of front-end inquiries and back-end inquiries, what I resist, and I think I'd like to resist it pretty strongly, is pressure on the in-between question. So when we talk about to what extent does complying with the law communicate endorsement, I don't like asking those types of questions. I think asking what's going on in a theological person's mind and to what extent they think they're endorsing something is the wrong type of questions for courts to ask. Courts are, I think, well positioned to put pressure on questions of sincerity, whether or not we let you into the RFRA free exercise game, and they're really good at figuring out if there's a compelling government interest that says, I'm sorry, we simply can't let you do what you're asking. But to ask whether or not we think you are actually engaged in endorsement of something you find problematic, I don't think courts are would do a good job at cracking open the skull of people and kind of trying to figure out what's going on in a religious mind. I don't think courts should be there. As we say, the law knows no heresy. And I guess to the same extent, I would resist questions about depth of conviction and consistency when it comes to substantial burden. I don't think we should be asking those questions. I do think we should be asking consistency questions when it comes to the front-end inquiry of sincerity. Are you indeed sincere? Are you acting consistently? To what extent maybe we can use the model that we use under our LUPA? I think that's really helpful. But to tell people that we as a government think that you're not engaged in religious conduct, the depth of your conviction is insufficient, You're insufficiently religiously consistent for the government's taste. I think those are the types of questions that courts and government should stay very far away from. If you're sincere and there's no countervailing compelling government interest, my view is we should let it go through as a larger structural matter. If you're not sincere or there's simply something too important from the perspective of civil society, then you don't get your accommodation. But I think the in-between questions are things we should stay away from.
Thank you. Well, first,
I hope I didn't misunderstand what you were saying. I may have.
yeah, you did, and I apologize if I wasn't clear, because what I was saying was not that courts should ask whether the individual believes that compliance with the law is endorsement. I'm saying that the court should start with the point that merely complying with a generally applicable law does not communicate a message. And then go on to inquire as to whether there is a substantial, or I would say, I think this is what Marty was getting at, a sort of disproportional burden. Obviously, that's not so easy to define, but that's the direction that I was suggesting. Personally, I don't think courts, it makes me very uncomfortable to think of courts inquiring very strenuously as to sincerity of one's belief. I mean, some beliefs are obviously bogus, but there are a multitude of religious faiths in this country, and there are probably only going to be more. And we're talking about faith groups that have a community of interpretation, not just the Church of Nan, who thinks Nan shouldn't have to pay taxes, right? I mean, funny thing about that.
You have to call it the Church of Man and Michael.
Yeah, right. Or your initials have to be NDH. So, I mean, there are a few people who could join. But whatever. I mean, obviously there's some bogus. But, you know, to have courts sort of cross-examining that makes me nervous. So there was miscommunication, and I apologize if the miscommunication, to whatever extent the miscommunication was on my end. In terms of the likelihood of how many such claims there are going to be, I mean, that's obviously not for a court to determine. I'm not judicially, I don't think that should be probably terribly relevant, but it's also disconcerting. I mean, 5 years ago, 10 years ago, certainly, if one were to say, well, what will be the outcome of having adoption of same-sex marriage, significantly throughout the United States, the word that came to mind over and over again, or came into the discourse, was backlash. Backlash. You guys should stay away from that because you're going to trigger backlash. There's going to be amazing backlash. And so to say, well, so same-sex couples can get married, and we don't really think anybody's going to discriminate in provision of services. Maybe that's true, but I don't know. Maybe it won't turn out to be true, at least in some places. I really don't feel confident predicting either way. I'm not predicting enormous backlash or harm, and I'm not predicting everybody yawns and it goes away. I think it's probably going to vary from place to place. And so I think that's a dangerous ground upon which to try and build a response to these difficult questions. I'll leave it there.
I'm happy to, it'll come up in Q&A, so.
All right, we're open for questions and answers. Doug, do you want people to go to the microphone, or?
It would be helpful for the people that are listening to the webcast if people could go to the microphone.
So if you please could go to the microphone in the back, and why don't you start? So there's a microphone. Yeah. Why don't you start? There's a microphone in this. And the panelists have been great sticking to their time limit. So if you can be short with your comments and questions.
I am Angie Rosen from the Government Department here, and I was really struck by Professor Letterman's question, how important is this whole topic of women have more cases and claims. It set my mind to thinking about it from the point of view of a political theorist, not a judicial scholar. And it goes back to things that Martha and Louise were talking about last night about current social movements and the political climate of the time as part of the answer to this question of its significance and its ongoing nature. And I think that Martha talked a lot about the civil rights movement, but the social movement that we've been living through has been a social movement that combines religion and anti-governmentalism. And I think that this is important in a way. One of the reasons why I suspect is these claims that they're not get in court are going to be ongoing and perhaps escalate. I'm just putting that on the table as a consideration for what's going on moving forward.
Great, thanks. Yeah, good.
Hello. Hi, Aram Chevet with the Center for Reproductive Rights. One very brief comment and then a question for the panelists. I'm just responding to Professor Geddick's comment about the way that the exemption and then subsequent accommodation were rolled out. I think one thing just important to keep in mind about this, whether being a real controversy as it is now or feeling a little bit ginned up at the beginning, is the fact that the original exemption proposed by the White House was virtually identical to the accommodation that had gone through with fairly little fanfare in both California and New York and were upheld by the California Supreme Court and the New York Court of Appeals. And it wasn't until it came to the national stage that this suddenly became controversial. But a broader question, I think, for all the panelists is this. Obviously, there's been some discussion about the substantial nature of the burden under the Religious Freedom Restoration Act. And I certainly have some sympathy to Professor Helfland's point that courts are ill-equipped to deal with this. You know, how important is it to the Jewish people to have circumcision? How important is it for Muslims to be able to have access to halal meat? Is not a question that courts can really engage in very easily. At the same time, I think there's real concern that if the religious party that's aggrieved gets to make that decision, it essentially reads out substantiality completely. And I think the point about attenuation has been raised with regard to the insurance coverage as opposed to direct coverage by employers, and now sort of almost at the level of reductio ad absurdum by the Little Sisters of signing the form indicating that you have an objection becomes itself objectionable, though not, of course, filing those papers in federal court. And I do wonder about the concern about reading out substantiality completely and whether there is some kind of middle ground, and you know, the possible result being that if all of the weight is borne by the compelling government interest, we get to a point where we say, well, of course, if Congress decided to take its valuable time to do this, it must be compelling. And then that sort of reads out compelling out of the statute as well. So is there a middle ground on substantial burden? Is it the court's decision, or is it the religious party's decision, or how else do we negotiate that? Thanks.
I guess that's for me. You want to do that? All right. Okay. Substantial burden. So in some of the attenuation questions, you mentioned Little Sisters of the Poor. I guess I don't feel like the attenuation questions, even in Little Sisters of the Poor, my gut reaction is I think maybe what you anticipate. I actually think we shouldn't be asking how much attenuation is too much attenuation. I think it's a bad question it's not the business for courts to get into that. I think it'll just cause real problems. I think the answer to that is really pressing on sincerity. I mean, to the extent that this attenuation is sincere, it is what it is. That's the burden experienced by a particular theological or religious mind. We need to find ways to press on sincerity to make sure that people making these claims are for real, and then the government should do what it does best. And if I have to decide which piece of the statute is going to get closer to being read out, I'm much happier with it being compelling government interest than I am with substantial burden. I think the law knows no heresy has to be kind of the baseline. We can't say, I'm sorry, we've determined as a government that your theological claim is too attenuated from your religious perspective. I think the government can do a good job in saying, we have too strong an interest here to take your claim, whether it's Little Sisters of the Poor, whether it's circumcision, whether it's Bob Jones. We have too important of an interest to accommodate here. We're sorry. And I think there's a strong dignitary piece to that. I know I've said that a couple of times. But when somebody comes to the door and says, I'm engaged in religious conduct, I think it does far more damage to them to say, we the government think you have insufficient conviction, you're insufficiently consistent, come on, this is too crazy for us. I think that's a difficult thing to say to somebody, to send them packing in that way. I like to think that the idea of saying, we understand and recognize, we give recognition to your claim, it just happens to be the countervailing interest is too important. I think that's a far better way to do business under the circumstances.
So on this, I guess I do fundamentally disagree. I think that 99% of these claims are sincere. I don't think that that's the problem, and I don't think calling them insincere would be either correct or a good test. But more importantly, 2 points. One is that the compelling government interest part doesn't work because part of what we're talking about here is not just how should state and federal RFRAs be applied, but how should if we want to do what Martha was saying last night and create religious exemptions and compromises, how should those be crafted in the first instance by legislatures? How should they define the category of people who should get an exemption notwithstanding a compelling governmental interest in most of the cases? And I think the problem is courts are doing this. I think Doug is absolutely right. Courts have always been sub rosa, dealing with what they believe are depth of conviction and sorts of conviction. And if in a Hobby Lobby the court says, look, if you say, if Paul Clement says the courts will separate the sheep from the goats. Yeah, but if the test is if you say you're a sheep, you're a sheep. And you sincerely believe you're a sheep, you're one of the flock, right? Then that goes away. And I'd rather it not be done sub rosa, although maybe that's the right answer, that it be done sub rosa. And another way to do it is just as a matter of statute. I think this is what Nan was getting at. You could believe whatever you want. We respect your belief, your sincere belief. You might think it's an endorsement. In cases like Rumsfeld versus Fair and Zellman versus Simmons-Harris, the court has said that's fine. People might think it's an endorsement, but we as a society will not deem your compliance with generally applicable rules where you're not using your discretion to prefer one or the other as an endorsement, even if you think it is. You could do that on the burden side as well, on the complicity side as well. You could say if this is not the sort of connection to the underlying offense, right? I don't think most of us feel complicit when we teach our students or give them a recommendation, even if we know they're going off to do a job like, prosecute capital murder cases that I find morally deeply abhorrent. I don't feel complicit in that necessarily because I'm teaching the student. Other people might, but we might say as a society, we will only recognize complicity claims in those cases where, in other civil contexts, aiding and abetting, proximate cause, and the like, we would recognize your responsibility for that thing having been done, and we never recognize that your compliance with the law, it makes you complicit in wrongdoing. And so you could just draw the line there, and that gets the courts out of the business. I think the problem is that I think that might be the medicine might be too harsh in that case, so I'm looking for some sort of middle ground in which courts and legislatures can try to draw a line.
You want to go real quick and then...
I just want to make a quick point that, just a reminder really, that REFRA, when it was first introduced, did not have the substantial modifier in there. It was any burden. And it was to quell a rebellion by Harry Reid and state attorneys general about the administration of prisons that substantial was added. So substantial was intended by Congress to mean something, although I'm very sympathetic to Michael's point of view that it's not a good idea for courts to be telling believers what is and is not a substantial burden on their religion.
So who has their hands up for questions? You want to go up? And why don't we hear like 3 or 4 of the questions, and then we'll have a quick response at the end. So we're going to hear 4, and if you can be really brief in your comment or question, and then we'll...
Okay. Hey, I'm Catherine Franke from Columbia Law School. Nan? I wanted to press you on your second big point of tying our hands of making arguments based in morality, which I think are not only about accusing the other side of being racist, but are about a sort of visceral response to being called a pervert or a sinner or a killer, or the various moral arguments that are made on the other side. So I wonder what you think about Louisa's argument about dignity. That's a moral argument. And to what degree do arguments based in something other than morality help us deal with the structural issues you wanted to have us focus on? What is the outside of morality? What does it look like?
Well, look, Dan, if you can hold on to that, we're just going to get the questions.
Nathan Diamond, Union of Orthodox Jewish Congregations. To Professor Geddick's point about the coalition that will walk across broken glass to stop alternative approaches, I wanted to push back on that in 2 ways. One is, the role of the courts question, which is it the court's job to worry about the inferior capacity right now of Congress to get anything done, but also just from a historical point of view. So in the first few months of the Bush administration before 9/11, when the big push was on the faith-based initiative legislation, there was a moment there where the Bush administration and the Republicans trying to get their legislation through, the big controversy, and what Democrats were opposing the legislation, and what was put on the table was that if faith-based social welfare providers were going to be able to get government contracts, et cetera, there had to be a situation where a potential beneficiary who did not want to go to a faith-based program had to have a secular alternative available. And that was in the proposed statute. And in the House Judiciary Committee, there was this aha moment among the Democrats who had been opposing the legislation across the board. Wait a second, if we actually let this through, all of a sudden there's this potential for this huge expansion of social welfare programs because you just need one person to come in a particular geographic area and you get your social. If Hobby Lobby goes a certain way, that could shake things up, change the coalitional dynamics, and force Congress to act in the direction where the coalition who would walk across broken glass, doesn't want to. And we have a little bit of precedent to put. It was the Democrats that shot that down, not the conservatives.
Go on to the next. If you could just formulate a question, that'd be great.
My question's about the implied consent framework and the factual inquiry involved there. And I'm thinking about Notre Dame, which in the past has been the center of Catholic intellectual support for birth control, also led the movement of universities away from Vatican control. And it appears most of their theologians think that complying with the mandate would not violate Catholic doctrine. So in thinking about having notice and consenting to religious governance, who is the person who decides what the belief, or persons of the organization is, if the belief is fluid? And should people have notice of who those persons are or a particular doctrine? And I'm also interested in whether the panelists think that they've consented to religious governance at their religiously affiliated university.
We don't have religious governance in Georgetown.
I'm Bridget Dunlap. I'm here in my personal capacity, but but I work for the Center for Reproductive Rights.
Thanks, Bridget. And then a real quick question, because we're out of time. So if you have a question, feel free to ask it.
Hi, Liz Sepper. I'm at WashU. I just wanted to throw in and see what you thought on to Marty Lederman's list, the issue of religious anti-discrimination, because there have been a number of cases involving for-profits that claim to be religious as a defense to religious anti-discrimination suits. And I think a little bit by even thinking about this as religion versus civil rights, we're leading to an impoverished notion of religion, potentially.
It's really brief. Okay, so hypothetically, if the court favors Hobby Lobby and if ENDA passes, what do you think that would mean for same-sex harassment or abuse within religious organizations or institutions?
Okay, so we may not get to all your questions. We're going to go to Nan, Fred, Michael, then Marty. Just kind of 30 seconds if you can give a final shot. We're at time.
Answer in 4 words.
Okay.
Cumulatively.
Catherine, great question. Sort of relinquishing discourse of immorality is a big, big give. I don't see it. I see that can happen in a way that de-individualizes the accusations while still retaining claims for dignity. I think that's a difficult dance, and you're absolutely right to call me on whether civil rights advocates should do that, and I'll try and think through a more sophisticated answer.
So if I understood your point, you were suggesting that if Hobby Lobby wins and then the administration proposes in the next fiscal year to triple or quadruple Title X funding to cover the people, well, not just to cover the people who are left without the mandated coverage, but also to include things like IUDs and contraceptives, which generally are not covered by Title X funding. That maybe all the people I listed on my slide will actually support that.
Maybe not all of them.
Yeah, maybe not any of them. But I will concede, I mean, it's hard to know. And I don't want, I'm not suggesting that the court should decide whether something is, whether an alternative is politically viable before it can be considered as an alternative. I think that would be really bad for civil rights, too. But as I said, it just struck me as kind of a remarkable litigation position to take, that the government can do it even though all the people supporting my side don't want that to happen.
Man, I have a lot I want to say right now. Okay, let's try to do this fast. I want to start just by talking about I forget who asked it, the question about, well, it was phrased in terms of Notre Dame and not knowing exactly who speaks on behalf of the institution. I don't want to talk about the specific entity because I just don't know enough about it. But more generally, under an implied consent framework, if you can't tell who speaks on behalf of an institution, you don't have a strong sense. As a result, I think it's harder to find implied consent. So like if you're thinking about it structurally, like I'm not a big fan of inferring implied consent when you have some sort of corporate document that says 5 members of the board need to have a particular religious affiliation. I think it's unlikely that people joining have kind of pulled the charter or the bylaws. But when it's open and obvious and integrated into the day-to-day life of the institution, I think that's where the claim gets stronger. And you ask about being as part of a religious institution. Yeah, I do think I've impliedly consent to a variety of things, and intentionally so. I think to the extent that I give something up there, I get a lot in return. I join an institution that has a religious mission that benefits me kind of pretty much every day, provides me funding for things that I wouldn't receive otherwise, and is extremely sensitive to my own religious perspective. And that's why I join, and maybe that's to some extent informs my implied consent framework. I think I get a lot, and that's why I think the framework works. In terms of the dignitary harm questions, this is the part, and its relationship to access, this is the hardest piece of the puzzle for me. When I say that I want to punt and I want courts to start talking about compelling government interest, this is where I want them to do the work that my brain just can't do. I don't know where to draw the line. I was joking with Fred earlier this morning. I spent the past week just running through hypotheticals in my brain. How do I feel about this and that and that and this? And the answer is sometimes I think things that are mutually contradictory, and I don't know how to sort it all out. And I think the answer is this is a political question that I think courts ought to do the line drawing for. I think they should take a temperature and get a strong sense of what political society just can't tolerate, and that's where they draw the line. I don't think I'm personally capable of doing this. I don't envy the person who does the line drawing, but I think that's where the line drawing has to happen. Good. That was
Okay, I'll make 2 quick points. One on Notre Dame. I think, look, Notre Dame may have had position A at one time and takes the opposite position now. I think the people who are appointed to speak for Notre Dame state the position for Notre Dame. And that's not the kind of inconsistency that I was referring to. The fact that your religious views have evolved and you have a different view now should not be held against you. There's court cases to that effect. On the other hand, Notre Dame has not done very much to try to enforce. It actually has a rule that its students, by the way, cannot engage in premarital sex. They're supposed to be, right? They can be kicked. What? But they don't do much to enforce that. And in fact, when they add under court injunction, when they added contraception to their plan, they didn't even notify their employees and students of that and tell them we have a moral objection to this, it's not ours. It's that kind of inconsistency that I think should bear on it. The last point, I guess, is when it gets to the least restrictive means and compelling interest. Sitting there at the oral argument on last Tuesday, I couldn't help but think that Chip Lupu was on to something back 20 years ago. In saying, look, all of our intent in crafting RFRA and in getting it enacted was, purer than the driven snow, and I'm still in favor of it. But quite frankly, every single term in it was just a placeholder that's supposed to somehow correlate to what the court had been doing in its fits and starts over the course of a generation or two, none of which really describe what the court was doing. Substantial burden doesn't, compelling interest doesn't, least restrictive means doesn't. And it was really striking at oral argument that Alito, Scalia, and then the chief basically said, stop citing me these free exercise precedents. RFRA changed everything. They put a compelling interest and least restrictive means test in there. Congress inadvertently and unknowingly radically altered free exercise law in 1993, and we're just going to apply this by its terms. Least restrictive means, if least restrictive means the government could pay for it itself, whether it's politically feasible or not, Lee and Tony and Susan Alamo come out the other way. They're 9-0. The government could have paid for those at any time. So we do have a problem, this gets back to my point, a problem in crafting statutory exemptions either at the granular level or at this broad RIFRA level, where I think the terms that we're using have nothing to do with what we want courts to actually be doing, in fact.
Great. Whatever their performance consistency in other parts of their lives, they have been consistently great performances.